everybody. Welcome back. Good to be back for a little Karen Read action. It's been a while. And here we are getting ready to do it all over again. Well, I got to tell you guys, I am a little bit excited about today just because it's not that often that you have a case go to a mistrial, inability to reach a verdict, and somehow it ends up even more explosive after all that. Normally, it's a little anticlimactic, right? You've gotten the preview of the case, you see what the positions are, you have your idea of the relative strength of the sides and so forth. And so the second trial just kind of ends up being a less good sequel of the first version. We already know what's coming and all that. But boy, have things exploded now with this defense motion that is on the table. I have written about this on my Substack to give you guys a little bit of a preview of what my take is on this and how I think it's going to go. But I think the best way to summarize it really is that this is a situation where the facts are extremely sympathetic to Karen. These are pretty unequivocal statements that are coming from jurors seated in the case that absolutely, without question, they had intended to acquit her of second-degree murder and leaving the scene of an accident. And it's very clear, case law establishes pretty unequivocally that you cannot retry somebody that a jury has acquitted after considering all of the evidence without violating double jeopardy. It's pretty much the classic example of it is a situation where the jury gets to hear all of the evidence and makes a decision and says no go, and the state says, well, but we're going to try again with a different jury. Like, it's literally the harm that the double jeopardy clause was originally enacted to present. So from a factual standpoint, it's very, very compelling and very sympathetic from my perspective. It's just from a legal standpoint, it's just a major uphill battle for them to be able to make any progress here. And so it's just one of those situations where I don't really expect this to go the defense way. And I understand why it's going to be, but it's likely to be a situation where because it's really focused on the law and the legal reasons for it, it may strike a lot of people as unfair or as inappropriate, or as maybe the rules shouldn't be this way under these types of circumstances. There's a saying that hard cases make bad law, and it's just the idea that anytime you have general rules that are supposed to apply to everybody under all circumstances, you're pretty much always going to come up with a situation where it seems unfair to apply it in that situation. And so you end up in this trade-off between, do I stick with the principle, the rule that is supposed to be universal, at the cost of recognizing that I might be doing an injustice in this particular case? Or do you sacrifice the principle? Do you put that aside and say, look, the rules are meant to serve people. People are not meant to serve the rules. If we're not creating a just result, then is this really the rule we should be applying in this case? And guys, that's the nature of law as a discipline. That's kind of the constant struggle that it's always going through, and it's always evolving from, is just finding this balance between, you can't just have special rules for special people. You can't make the law up depending on what you want it to be for a particular case or a particular person. At the same time, everybody, I think, recognizes that just uniform, thoughtless application of the rules is not always getting us the kinds of outcomes that we really think are appropriate in our society. So it's a difficult situation. But we'll see. We'll see how it unfolds. We'll see how it unfolds. I wanted to look at this under Massachusetts law just because double jeopardy, of course, it's federal constitutional principle, and in and of itself, there's not a lot of difference there, from state to state. In any state under the federal constitution, if you retry somebody who's been acquitted of a crime, you are violating double jeopardy. But it's a matter of state law as to what constitutes an acquittal, what is specifically required for a verdict to be recognized, what types of evidence can be considered. Will a court even consider jurors' statements about what was going on in the deliberation room in order to make a determination about kind of what were legally significant facts in the case? So I did take a look at that. I broke a lot of that down in my Substack piece. If you are interested in that type of thing and want to see a little bit about my thought process and kind of how I got there. But the bottom line is there is not good case law in Massachusetts, not good case law. They seem to be pretty stringent on the formalities of accepting a verdict. I found one particular case that to me seemed pretty squarely on point. It's going to be hard to get around the implications of it. This was a case where a gentleman is being tried for a crime, and the jury is back in deliberations. They have reached a verdict on some of the charges, but not all of them. They have filled out the verdict slips to reflect that. They've signed off on them. They're all ready to go on these charges, except for the final one. The following day, when they're coming back for deliberations, one of the jurors is sick. So the juror gets released, and that means they have to bring in an alternate. And when you bring in an alternate, you have to start the deliberation process all over again. You don't get to just kind of plug them in where you left off, because they have to be part of the 12 that's in unanimous agreement about the outcome. So in this particular case, then the jury starts over their deliberations, starts over even with these charges that they had originally acquitted on, and ultimately they result in. Or I don't remember if they had acquitted or if they had convicted. They had reached unanimous verdicts. Anyway, they ultimately convicted the guy. And then later it came out that this had happened, that they had these final verdict slips back there in the jury room. And so this was an issue on appeal, and the Court of Appeals in Massachusetts basically said, look, all verdicts are preliminary until they are formally read and presented in court and affirmed by the jury, acknowledged by them as being their verdict. And so in the absence of any of those things, even though it looks a lot like a final verdict, and even to the point, like beyond what we have in Karen Reed's case, to the point where they had actually filled out and signed the verdict slip, the court said that's not enough to make it a final verdict for purposes of double jeopardy. So that's the rule they're going to apply, I have to assume, in this particular case. And if even having a signed verdict slip saying we are acquitting this person was not enough, if you don't go out and read it in court and acknowledge it, then a situation where we don't have that, we just have the reports of the jurors saying, hey, this is what our agreement was and what we had intended to do. I just am very skeptical that the Massachusetts court is going to find that to be enough under the circumstances. I'm interested because I did see reports that we have a different judge assigned today, and I don't know if this is intended to be just a temporary fill-in because it's summer, everybody goes on vacation, the courts always go on vacation, there can be a lot of filling in and stuff like that. It just happens. This could be a one-time coverage type of situation. But I'm also aware that the the Norfolk County Superior Court, they do assign their judges to certain case types, and then those assignments change over the course of the year. And so there is a new judge that is now assigned to the criminal case docket. And that opens up a question, a possibility. Oh my God, could we get a new judge? Is it possible we could get a new judge? I mean, that would be amazing. I don't think that's probably going to happen. It could. But it would be a little bit unusual for a case that has gone this far with one particular judge to just suddenly get handed off over something that is a little bit administrative. You know, the case assignments. Typically, it's just more efficient for a judge to follow the case from beginning to end once they get a hold of it. And so it's possible and probably even likely that Judge Bev is going to continue to be the presiding judge over this case. She's just not going to get any new criminal case assignments as they go forward. But just that possibility, that maybe we could see another judge's read on what's going on in this case. It would be so fascinating, I think, to see and to be able to compare that with what we already got. So honestly, even just getting that in a hearing, I'm excited about. I'm enthusiastic to see how a judge who has hopefully been a little bit distant from everything that has gone around surrounding this trial and the recriminations and the personality conflicts and just the whole tone that has been set in this courtroom. It could be very different today. So it's just going to be something that it's going to be an interesting shift in perspective to see potentially what we get from that. So the other, big question, we're obviously today, the purpose of the hearing is they're resetting the trial, right? So we're just going to get a new date and they're going to look down the calendar, look at what the schedule is, estimate how much time it's going to take, figure out when everybody's available, set it on the calendar, right? Nothing very fancy, just routine scheduling stuff. But I do wonder if there are going to be potential impediments to be able to getting that done today. And one of the things that has definitely crossed my mind is the potential for a motion for a change of venue at this point. I'm sure I have mentioned this before, but it's just a situation where it was already, I think, maybe a little bit challenging to get a jury that is separated from everything that has gone on publicity-wise, both just in terms of what the news is covering, the social media component to it, the protests, all of this stuff that's out there that just seems very likely to have captured the attention of the local community. And likely, I would think, gotten them to kind of come down on one side or another side. If it was hard to get an impartial jury before we tried to do this trial the first time, I just gotta think it's gonna be a lot harder the second time around because of just the increased publicity that was on it for the extended length of time that the trial was happening. All of the commentary, the out-of-town press is there. They're staying in the hotels. The protesters are showing up. Anybody driving by this area is going to see and be aware of what's going on. It just is a different universe as far as judgments of this case are likely to be compared to where it was before it went to trial. And I think part of the problem too is now that it has gone to trial, there is a potential for those kind of initial impressions to be a little bit more ingrained, because people feel, I think naturally, well, I am better informed now, therefore being more entrenched in my position is probably appropriate, because I'm not just reacting knee jerk to stuff that I read or guesswork that I'm making, you know, my thoughts about what motivates people and how they behave and things like that. No, we're basing it off actual evidence now that we saw in a court process. So I don't know what the like how many people in the local community were engaged with this trial on a real, you know, in-depth level, like, you know, we were here on the channel. Okay. So, that's just, if that is something that is going to come up, then that's going to have to be addressed before they can set a new trial date. So it looks like Boston 25 has us. So I'm going to go ahead and get that shared. I'm going to start at the beginning. All right, guys, here we go.
Messages, and then depending on the detail, radio communications are recorded.
Does the Secret Service have recorded communications from the July 13th event?
We do not have radio communications from that day.
But you
Seems
have
to
text
be
messages?
before court is in
We do
session
have,
here,
emails
but
and text messages.
Emails, okay, great. Does the head of the Trump detail or someone else embedded in this
Things that are
current campaign
a number of other
I'll
agencies.
just skip
the
us till I see somebody on the bench.
Oh,
it's Judge Bev. Well, what a downer.
Homeland Security that are assisting us.
but not local law enforcement
Local law enforcement is working on their own.
on the same frequency?
We ensure that we have counterparts in the security room. And
I'm trying to figure out what's going on here, because they're giving me sound I don't like, telling me about political stuff when I'm trying to listen to the trial.
Local law enforcement will place one of their personnel in the security room with our personnel so that we have interoperability communications.
Let me ask you something just about the timeline, because I think this is really interesting that we can't nail that down. I mean, I think there are lay people out there with more knowledge about the timeline than you seem to come before a subpoena in front of Congress. Was Mr. Crooks observed at the AGR building prior to the shooting?
All right, guys, I'm going to try to find a different channel here, because that's going to be intolerable. So we're still waiting on Law and Crime, it looks like. Let me check Court TV.
From ECPI College of Technology. However,
Not seeing anybody else live yet, so very, very annoying. Okay, I found one that seems clean, so let's give that a try here. Thank you, NBC 10 Boston. Okay. And they're already done. So let's go back to the beginning. Well, looks like maybe this is not going to end up being the most exciting or extended of hearings today.
Now open your ABC.
All right.
That's 22117, Karen Reed. Can I have counsel identify themselves?
I'm for the Commonwealth. Good afternoon, Your Honor.
Good morning. Good afternoon, Mr. Miller.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Mr. McLaughlin.
Good afternoon, Your Honor. Martin Weinberg, appearing on behalf of
The sound is quite bad.
Nice to see you.
Good afternoon, Your Honor. David Benetti for Karen Reed.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Reed. All right, so the case is scheduled today for trial assignment, and what I'd like to do is to get 3 dates. I'm aware that a motion to dismiss has been filed. I'd like to get a quick date on that, and I'm glad you're here, Mr. Weinberg, because I'd like it to be dismissed. Then we need a trial date, and we need a final trial. So I was thinking on the motion to dismiss, can we do it a week from Friday?
So they're going to set a separate hearing on the motion to dismiss.
August 2nd, Mr. Clerk?
I'm going to be out of state. I return on August 3rd.
Okay. August 9th? Are you available, 2 o'clock, are you available, Mr. Weinberg, on August 9th? Mr. Lally, is the Commonwealth available on August 9th?
Yes, Your Honor.
All right, so that's for oral argument, okay?
So the motion to dismiss, August 9th, 2 p.m. We will definitely watch that.
So given the schedule, and I assume whatever I end up doing on the motion to dismiss will be appealed, in an effort to make sure we have plenty of time, I would like to schedule the jury trial on January 27th. Is the Commonwealth available?
That's fine, Your Honor.
Mr. Eddie?
That should be fine.
Okay, so January 27th, the trial. And let's do the final trial conference the week of the 13th or even the week of the 6th. Do you have the calendar for any of those days?
Yeah, there's nothing, just not the 9th or the 16th, but all the days are open. Your Honor, the only caveat, I don't have anything on the 27th. I'm clear for that date, but for the fact that I have a Superior Court trial scheduled to begin in Essex County on January 13th. There are multiple.
How long do you expect it to
That's what I was getting to. That could take longer than 2 weeks. I'm happy to have this case take priority over that, but that's.
No, we'll hold it for you day to day if need be, and I can contact the Essex Superior Court judge once you know who he or she is.
Yeah, that's not ideal. In terms of preparing for trial, I can't do 2 or 3 weeks Superior Court trial and then jump into this case. I can't do that.
Okay? So what are you telling me? You just said you're willing to make this a priority, so we'll stick with the 27th?
Well, okay. Well, why don't we do this? Let's put it on to the 27th. Let me see if I can make peace in Essex County. And then on the next date, when we come back to oral argument, I can readdress the court on that issue.
Okay, I'm happy to talk to Judge McCarthy and Mr. Raj up there about this.
It's yeah, okay, that's great.
All right, so let's set it for the 27th. And why don't we do the 14th for final trial conference?
The 14th at 9 or 2?
2. If it turns out that we have, in excess of 35 or whatever motions to eliminate still at that point, let us know and we will try and get the whole day. Okay? All right. Thank you very much.
Thank you, Your Honor.
All eyes support, please.
So that's that. Nothing fancy, just dates. Well, I don't know if you guys could hear that. The sound for me was quite bad, but at least I did not have to listen to the Secret Service hearing instead of the court. But here's what I got. It looks like we are going to be having the motion hearing on the motion to dismiss on August 9th. So that will come right up in just a few weeks here. Trial date, January 27th of 2025. August, September, October, November, December, January. She's kicking it 6 months down the road, guys. 6 months down the road. Let's talk about what that means. And then the final trial conference on January 14th of 2025. So let's talk about all this just real quickly. What some of the takeaways are from this. So obviously not dealing with the motion hearing today, going to take it up on August the 9th. Does this mean they can submit more evidence? Yes. I see no reason why not. If more jurors continue to come forward, more information continues to come out, then yeah, I don't see any reason why they wouldn't be able to supplement their filings. It would just be a question of, does the other side need or get an additional opportunity to respond to that? I don't expect, though, for the reasons I've already said, I don't expect that it's likely to significantly change the legal posture, even if that does happen. What I think it's really likely to do is just shift a little bit of the public perspective on the case, potentially. It just, it puts pressure on the Commonwealth from what is just more of a, I hate to say PR because it sounds derogatory, and I don't really mean it in a derogatory way in the sense. I just mean in the sense that the prosecutor is supposed to be a representative of the community. And so if the community doesn't want a prosecution to go forward, doesn't think it's a good use of resources, doesn't think it's a good case, there's an argument to be made that the prosecution should be receptive to that. So to me, this undertaking looks a little bit more like an effort to put the pressure on the prosecutor in that sense, to basically walk away from the overcharging, essentially. Like, look, this does not seem to be a murder case. The evidence did not look very strongly like a murder case when we watched it at trial. And the jury did not seem to buy it as a murder case either. So why don't we just go ahead and ratchet down on the jeopardy and follow the wishes of the community, just on a voluntary basis, maybe drop that charge and just go forward with the voluntary manslaughter and the lesser includeds to that. Don't think the Commonwealth is going to do that. Can't say I'm optimistic that the Commonwealth is going to do that. But it's really their job to try, Just because an argument is not likely to win, it isn't likely a winning argument from a legal standpoint. That doesn't mean you don't bring it. It doesn't mean that there's, no justification for it. Definitely doesn't mean that it's a frivolous motion. And so if there are other upsides that they get, and one of those is the putting pressure on the prosecution, then, that's to be expected that they'll do that. But so August 9th, then we'll get oral argument. Doesn't sound like there's testimony anticipated. Certainly it's part of the defense motion that they want there to be an evidentiary hearing. So they'll probably be asking for that in their oral argument. But just the posture of how this was set suggests to me that that's unlikely. If there was going to be an evidentiary hearing, it seems very likely to me she would have just gone ahead and set that, because the jurors need to be located. They need to be subpoenaed, compelled into court if they're going to be compelled into court. It just doesn't look like a very high likelihood to me that that's going to go anywhere. So my suspicion, we're going to go in on August 9th, and, the judge is not going to be willing to consider the jurors' statements about what their verdict was in place of the verdict. So maybe just a formality, this oral argument hearing, but we'll see. Okay, so a final trial conference on January 14, 2025, and she made mention about, if there's 35 motions or whatever still pending. So they're reopening the motions in limine. This is also somewhat typical, but also cannot be. In this particular case, I think the big significance to it is the new opportunity that the defense is going to have to argue for the third party culprit defense explicitly, because now they have gone through their trial case. They have put forward the evidence that tends to suggest it was somebody else and not Karen Reed. I still don't know if this is going to be enough for Judge Bev, but it's a great record now that they have to rely on, because they can point to not just here's our evidence of the circumstances and the potential motive and the suspicious behavior that looks a lot like a cover-up after the fact. But now we have direct evidence of stuff like, Lucky Loughran saying there's nobody on the grass at the time when he should have been there. If that's when Karen hit him with the car. That's got to pretty squarely put it on somebody else and not on Karen Reed. So typically, the judge is not going to deviate too much from rulings that they made the first time around. But the question, it really can be a lot more flexible in a situation where the ruling is based on these foundational types of requirements, where you have to make a certain showing to be entitled to do something, and your ability to do that kind of evolves over the course of the trial. Then now that we have the whole trial to look back on, we definitely have a different perspective on what came out, how it came out, the potential effect that it had. And so it could reopen some of these previous questions. The issue about the harassment of witnesses and that door, she had ruled that door was opened in this trial. Is that going to be off limits again in the next trial? And maybe they'll just tread a little bit more carefully. It's very possible. Very possible. Evidence about late disclosure of things. The kind of gamesmanship that was going on with a lot of this evidence, the wait until the last minute, spring them on them kind of thing. Opportunity to maybe comment on that, probably not so much, but it's just interesting to think about what opportunities they might have to be able to go back and argue to Judge Bev about what they should be allowed to do this time, given what they learned from the first time around. So then trial January 27th, 6 months away, 6 months away. A lot of stuff can happen in 6 months, guys. A lot of stuff can happen in 6 months. Ever since the Sallyport video came out, that whole inverted video from Sergeant Buchanan, boy, that is a discovery invitation like I haven't seen in a while. That is just the kind of thing that, of course, had the jury reached a verdict, discovery's closed, you never have an opportunity to go back and follow up on that, sort that out, figure out exactly how did this happen. The story that we were given about how this happened, does that really line up with reality? They got a lot of time now to go down that road, potentially go down that road and try to get some answers to some of those questions. Who inverted it? Was this really just an automatic thing that the camera did or that the download did? Nobody knew about it? Just a very, very unique opportunity that they have to potentially blow up some more of the credibility of the Commonwealth's witnesses, right? This was Sergeant Buchanan who got up on the stand and sponsored this particular video. So, yeah, couldn't have the time to get all that sorted out the first time through, but now we got 6 months to go down that road. So, of course, as we know, the the internal affairs investigation against Michael Proctor is continuing. And there's been, some preliminary action taken. He is finally not on a paid vacation anymore. Stranger things have happened, but boy, hallelujah, who knew? Who knew? My guess on that had been that he would get the paid administrative leave while they go through whatever disciplinary proceeding they need to get to, and he's got union lawyers on his side that represent him. He doesn't have to pay for that himself. That's something that is provided to him by virtue of the position that he holds as a law enforcement officer. And so those lawyers are negotiating with the Massachusetts State Police. They have the leverage such that it is for law enforcement because they control the workforce. So they don't just have to push for Michael Proctor's interests here. They get to hold him up as an example of the threat to all the other law enforcement officers, depending on how this particular situation is handled. Hey. So I had just anticipated, keep him on administrative leave. The lawyer will negotiate some kind of golden parachute for him so that he doesn't have to be an embarrassment to the agency anymore. But it wouldn't be a complete throwing him out in the cold, like actual consequences. Does that really happen? Well, wow, lo and behold, it kind of looks like it might. So he is no longer on paid leave. He is on unpaid leave. And there's a lot of room for this to continue to unfold as well. If he is terminated, if he's fired as the result of his conduct in this case, oh, you better believe that's coming out in the second trial. That is very much going to be an issue that goes to impeach him and impeach his credibility, impeach his investigation. Now, one of the things I'm interested in looking into a little bit is trying to sort out how much the defense might be able to find out about what's going on in this investigation anyway. See, I found it a little bit alarming, troubling. It bothers me that the announcement, even from the Massachusetts State Police about this process, is basically that it's just about his words, right? It's about his words, the language that he used in the text messages, and not necessarily the problem. Like, the language is the symptom of the problem that Michael Proctor really had, which was his total lack of objectivity displayed in this investigation. And so the text messages were just giving that away. The problem is not he was otherwise a good cop who just happened to use some bad words. So it's always hard to know what is just statements, just the public face that the agency is putting on an incident like this versus what are they really concerned with and what are they really doing behind the scenes. And the problem is with employment types of issues, often you don't get to see it. It happens behind closed doors. It's not publicly disclosable. It's typically exempt from those kinds of like public records obligations. So I'm interested because I would like to know how much we're going to get to know about what is actually happening in this IA process. How transparent is it going to be? Because is the defense going to be able to look at that, get a record of it, see what was said, see what was not said, see what they were really focused on from a behavioral standpoint? It is the type of thing that sometimes, even if it's not publicly available, because it's so intimately related to the law enforcement officer's bias and to potential impeachment, that a lot of the times they can get it even if the public can't. It would just be one of these situations like we've seen so far where it's subject to a protective order. If they use it in trial, great. If they don't, then it's unlikely to be made public. But just another issue that's likely to have plenty of time to unfold over the next 6 months. So these are all things that seem pretty likely to me to benefit Karen. Maybe we can follow up more with the crash daddies. Were there things we didn't get from the crash daddies that it would have been good to get? I did have concerns. I can't say I question because it wasn't the defense call, right? They didn't hire these guys. They didn't get to decide what the scope of their investigation was, what kinds of opinions they were going to offer. But it did trouble me that at the 11th hour in this trial, out of the blue, we were now getting a completely different theory for the taillight being broken, which is that maybe the glass was thrown into the taillight, and that could have been consistent with the damage to the taillight as it was seen in the Sallyport video. That throws a wrinkle in the defense case. A big part of the argument for the third-party culprit is because the physical evidence can't be reconciled with a version of events where Karen Reed is responsible for hitting him with the car. That's the reasonable doubt. That's the reason to find her not guilty. Can the Commonwealth build a new theory of the case around the crash daddy testimony? There's nothing legally that says that they can't. Right? They're just in the same boat as the defense as far as what the attorneys argue is not evidence. Like, it's not like the defense would be able to get up and present to the jury Mr. Lally's closing argument from the first trial, because it's not evidence. It's just the position that they took at the time. So what they would ultimately have to do is they would have to go back and revise essentially the parts of the case that supported their theory about the, backing up at 60 some miles an hour, and whatever. Or maybe they just incorporate that somehow. I don't know. But they can accomplish a lot of that by just not calling Trooper Paul. They could get a new witness, a new expert, somebody to do a reconstruction theory where now the focus is on the throwing the glass into the taillight or something like that. It's really not off the table. And if Trooper Paul is not called as a witness, then you don't really get to impeach the Commonwealth with, hey, but Trooper Paul said it happened this other way in the first trial. Now, the defense maybe could call Trooper Paul themselves under that scenario. There's just so many crazy possibilities that come up when you're in that redo situation. So I've been trying to brainstorm, like, are there ways that this gets better for the Commonwealth? having another 6 months to think about this, to wait, to build up the case, is there a conceivable way that helps the Commonwealth? And this is really the only one that I can come up with is, well, they do have time to revisit their, for lack of a better word, mechanical theory of how the crime happened. I mean, frankly, anything different would have to be better than what they gave us, wouldn't it? Wouldn't anything be better than what Trooper Paul gave us the first time around? But that's about, honestly, guys, that's about all I can think of. And so in pretty much every other respect, this delay seems to me to be very beneficial to the defense. So again, there's always the cost standpoint. From that perspective, no, that's hard. It's hard to have to pay longer, more, again and again. More stuff comes up, the more you have to pay for it. That part is very much not easy. But the fact that they can potentially continue to dig into some of this evidence, particularly the late discovered stuff, the things that look bad, they can dive more into the details and see how they might be able to help us. I mentioned previously, it's like a golden opportunity the defense has here to really focus group the case. Like what were the details that people thought really mattered? What were the ones that they didn't really understand? What were the points, the big kind of decision points that people saw that the defense could give us more clarity on the second time? For me, a big one remained the tail light, the details of the tail light, because that piece of evidence was so critical. It was so central to the defense theory that this was a frame job, because they have to explain the taillight found at the scene on the night of January 29th during the search. And there's just limited ways to get there, without getting to a cover-up. So drilling down on some of those details, like we saw some of the sleuthing that was going on online as this evidence was coming out, folks were tracking like which piece of evidence was found. I'm still waiting to know if there was extra plastic. I never learned. Was there extra plastic? That would be really significant to me. If there's more taillight here than would fit into Karen's car, looking at all of it, it seems like there must have been, but I just don't know. So they have an opportunity to dig deep into those details and continue to work on bringing them out and demonstrating them to the jury in a way that makes it clearer and clearer and clearer how that evidence points in favor of their theory. 6 months is a long time. There's no longer really a speedy trial consideration. I mean, there is, at least in theory, and that there's always a constitutional speedy trial outer limit, but that ultimately is just reasonableness when it comes right down to it. Was it unnecessarily delayed? Was it prejudicially delayed? That's the constitutional standard is extremely difficult to meet. And so 6 months even is well within the time frame for that to be even like presumptively a problem. It's not an issue there. So they have the time. They might as well use it. It does make sense that this is probably down the road far enough that they don't have much else scheduled on their calendar. So they can set it. They can be pretty sure it's going to go forward. They can work around it as they move forward in their summer and fall dockets and are setting things down the road. They will know what kind of time frame they don't have available in light of this trial. I still remain interested to see. She didn't give us a change to the length. She didn't suggest when the trial is going to end. She just told us when it was going to start. And I do wonder if that is something that, there may be a learning experience from that the first time around. I don't know. It sure seems like we, watching from the outside, saw an awful lot of repetition, unnecessary, cumulative things that didn't matter. Did Bev not see it that way? Or is it just that she gave so much leeway to the Commonwealth to decide how they wanted to present their case that, they were going to get the time they wanted, and that was pretty much going to be that. I don't know. It will be interesting to see if there's any effort at all to kind of try to ratchet down on some of that the second time. Well, those are about all my thoughts, guys. I can't really think of much else. January 27th. It's going to be, middle of winter in Massachusetts. Yeah, this could be a whole issue. This could be a whole other issue. Seems reasonable to expect that it's going to be less pleasant to protest a trial. Show up and hang up outside all day with signs and things like that in the middle of winter. Probably seems likely that it won't be maybe such a big deal. But if people really believe the weather's not going to stop them, whole new potential for issues with interruptions to the trial, jurors not being able to get in if there's bad weather. Another one of these storms, and I don't mean an 18-inch storm that's really a 4-inch storm. I mean like a real 18-inch storm. Yeah, I mean, what do you do in that situation? Do you recess the trial? Do you end up losing jurors? It can just create a whole different set of complications having a trial in the winter. But I'm sure they're used to dealing with those things. They're not new to the area, so that would be a little bit ironic, I think. But yeah, we'll just see how all that unfolds, guys. Let's go ahead and take a look at some of your comments here. Missed having the questions and stuff. I do want to say, well, I'll come back to this. I'll come back to this thought. So Ed 2276, did the rule require Bev to ask the jurors if they had come to a verdict as to any of the charges before dismissing them? No court could rightly say her failure to do so amounts to harmless error. The rule does not require her to ask them specifically. So what the rule says, in fact, I might even be able to pull up the rule. Let me see if I can find it real quickly, because I pulled it up in my Substack. And so might be a situation where I can just get... Now it's going to be complicated. So basically what the rule says is that she is allowed to take a partial verdict, and there is some indication that she is required to take a partial verdict, basically if she's aware of it, if the verdict is, kind of there. And it also provides that she has discretion to poll the jury on the verdict. Now, this is where you get into some kind of gray area and what does this language actually mean? And so typically when they're talking about polling the jury on the verdict, this is a situation where there is a verdict. The jury has come in, they've announced, we've reached a verdict on these counts. Whatever the verdict is, guilty, not guilty, it's unanimous. And the polling is a process where the court basically goes and asks each one of the jurors to confirm that this was in fact their verdict. And so it's not meant to be an exploratory questioning, like to get information about where the decision stands. It's really just meant to be a corroboration for the last option, the last opportunity if a juror had been left out, maybe a situation where there was a holdout and the holdout went to use the restroom and everybody else decided we're just gonna get it done and try to rush it through or something. This is kind of a not realistic scenario, but is generally what it's there for. It's to be the last resort opportunity for a juror to say, actually, in hindsight, I'm not unanimous on this. I actually don't want that to be my verdict. So this is the affirmation of the verdict in open court that's accomplished through the polling. It's not required. It's discretionary with the judge. So question number one, was she required to ask them if they had a verdict on any of the counts? It does not appear that she is, that the law requires that. It seems to be a situation where it's discretionary. And so when it's discretionary, it's based on what's reasonable under the circumstances. Was this so out of the range of what a judge should do that no reasonable judge would take this position? And so understand, under the circumstances here, I just don't think they're going to meet that because they didn't have any indication, as far as we know, that the jurors had apparently reached agreement on any of the charges. And so it's a little bit of a different question than if she had asked them, were you able to reach a unanimous decision on any of the verdicts? Would that have been error? Probably not. That probably would have been within her discretion too. But it's actually a situation where it gets a little bit more precarious the more down that road she goes, because you get closer and closer to the possibility of putting pressure on the jury to decide something, coercing a decision from the jury, which the law is very clear you're not supposed to do. You must give them the space that they need to be able to make their decision without putting your thumb on the scale or suggesting that they have an obligation to work it out or resolve it or decide something at all. I don't think it would have been error under those circumstances to ask, because I don't think that's particularly, I don't think it's really coercive to say, have you been able to reach a unanimous agreement on anything? But that's not what happened. That's not the facts as they unfolded. So she exercised her discretion, or just maybe never even occurred to her to ask, honestly. Just no reason to think this was going to be an issue. So just going to take it at face value. They've said repeatedly, we can't reach agreement. We're divided on fundamental issues. It does make it sound like the jury is just far apart on everything. So under those circumstances, is it unreasonable for her to think they probably did fail to agree on everything? I don't think so. And especially not if they aren't coming forward with signed, completed verdict forms for the ones that they were able to agree on. I think if there's a situation where verdict forms had been handed to the bailiff on some of those charges and she hadn't inquired into that, we'd be in a very different situation. We'd be in a very different situation then, because yes, then what reasonable judge would not ask? Were you able to reach a verdict on these charges? I mean, you absolutely would under those circumstances. But without that verdict and without that evidence, I don't think it was likely going to be. It's just not a situation where the judges on the Court of Appeals would look at this and say, that was just a bad call under the circumstances. So one of the areas where, judicial discretion can kind of go both ways. But yeah, if she had asked, we could be in a very different situation. Or if the Massachusetts law did require her to ask, if their rule said, before declaring a mistrial, the judge will inquire into, the jury's ability to reach a unanimous verdict on any of the counts. If there was a rule like that in place and she didn't do it, then yeah, would we be looking at harmless error? That gets us back into that question of how much these juror affidavits can really even be considered. This is an area of the law that it's pretty black letter, I think, for trial practitioners, but it's probably one of these things that looks very different to lawyers than to lay people. The whole rule behind this, that you don't get to use jurors' testimony about what happened in the deliberation room to challenge what they actually did in the deliberation room, is because it just undermines the principle of finality in trials altogether. If you can always go back and convince a juror to kind of rechange their mind, I was pressured, I didn't really agree with the verdict. I mean, we know this happens a lot. It happens a lot. Like, that's the process of deliberation, getting 12 people to unanimously agree on the same thing. It's going to require a lot of compromise along the way, and a lot of that compromise is likely to be reluctant. People don't necessarily love it, but go along with it. And so if that's now, no longer definitive, it kind of undermines the purpose of having a jury trial in the first place. And the point of the jury trial is that we're just going to put all of the evidence out there and the people are going to decide, and then it's going to be done. And we're going to move on from that particular judgment. So it takes that off the table. It means that the verdicts are always then going to be vulnerable to challenge if jurors are willing to say why they disagree with the verdict, why they don't think it was their verdict, why they don't think, they were really unanimous in that verdict. And it also then creates an incentive to go and lean on the jurors, to convince them. Maybe if you had some doubts, maybe you should raise them. Maybe you should be vocal. Even to the point, not that there's any indication of this happening here. All indications, of course, are that these jurors came forward voluntarily of their own volition, went directly to the lawyers. The lawyers did not reach out to them. But you can imagine a situation where that's not how it goes, where the lawyer loses and the lawyer maybe is not so scrupulous, or the lawyer maybe represents clients who are not so scrupulous, and those clients are more than happy to, metaphorically speaking, make the jurors an offer they can't refuse, as far as their confirming the verdict after the fact. So it creates incentives for potentially bad behavior, because it would get you a second bite at the apple, get you a new opportunity to try to get the verdict to go your way. So from a legal standpoint, there's good reasons why the jury confidentiality needs to be in place, and that's just above and beyond. To have a good deliberation, at least in theory, in principle, the jurors kind of need to feel safe in there. They need to feel that they can say what they really think and go through the process in accordance with their consciences, and not have to be worried that that's going to be outed, that somebody's going to come out and talk about the things that you said and how stupid they were, and, you know, your questions were real dumb, just da 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 da. That would be real discouraging in the jury room if you know, yeah, all these other people, they can come out and talk about your decision-making process, especially if they didn't like it, if they don't like how you thought through this case, and they, you know, maybe bullied you into coming to the decision that they wanted. It's just not real conducive to being forthcoming in that process. And so people would be more likely to shut down and just not really participate, not really work things through, you know, worry about looking stupid, worry about being embarrassed, worry about just, you know, judgment, the judgment of other people, shame from other people. Very, very powerful motivator. But at the same time, it sure does seem weird, doesn't it? That a juror can tell you, this isn't what actually happened. This isn't what actually happened. And because of that principle, because that jury room, it needs to be sealed and closed. It's like a crypt. It's walled off. You don't get to go in there and use that stuff. You don't get to use the stuff. You don't get to use the stuff. You know, it doesn't matter which way it's coming out. So, yeah, I can definitely see why this is one that a lot of people, you know, are going to see as unfair. I totally understand that. The law is very weird sometimes. It's really about all I can say about that. OG Kush is a YouTube member. OG. Something like that. Track worker. Why can't Nazi Bev just admit her screw up and fix it? Well, she will definitely not admit her screw up. That's just not really a thing that judges do. And as we've seen from Judge Bev anyway, over and over again, she blusters before, you know, backing down. What we'll hear from Bev is a lot about her discretion to act the way that she acted and how she's well within her authority and the law is clear on the point and yada yada. She will make it sound pretty definitive in her favor. And honestly, you know, again, just from a legal standpoint, it is going to support her. The law is going to be on her side. So, yeah. Very unfortunate situation for Karen. The judge's perspective is going to be, it falls back on the defense lawyers. That's how she's going to see it. If they wanted me to do something other than what I did, they had the duty, the responsibility to ask for it. If they didn't ask for it, I could not have known that they wanted it. So if they wanted me to poll the jury, nobody asked. If they wanted me to avoid declaring a mistrial, if they wanted me to do something other than declare a mistrial, they didn't bring it up. I did see some questions circling about kind of the opportunity to respond, and was this a situation where you go back and watch how the mistrial kind of came down. They come back into court. Judge Bev just announces to them the jury is deadlocked. And, you know, after they had gotten the Tui Rodriguez, and she just tells them she's going to declare a mistrial. Didn't read the jury note out in court at that point in time. But then just immediately brought the jury back in. And so I know a lot of folks saw that and thought, well, wait a minute, she didn't invite any kind of input on it. She didn't ask the defense to take a position on it. So was this a situation where then they didn't have the opportunity to give their input? Well, I think that might be pushing it, because they could you can object. The judge says they're going to do something and you don't agree with it. It's your duty to stand up from your desk and say, Your Honor, I object. So that clearly didn't happen in the case. But there is a little bit of a nuance when it comes to the mistrial. And the reason why is because if a defense requests a mistrial or like joins in a request for a mistrial, it waives objections to that mistrial being declared. And that means then, you know, any sort of double jeopardy issue that potentially could be there is no longer there. So the only time double jeopardy is implicated by a mistrial is when it is not at the defense's request. The defense is not joining in it, and it's a situation where there is there's no manifest necessity for the mistrial, meaning it's, you know, it wasn't necessary. Like, it's possible other remedies, other actions could have resolved whatever the problem was, short of having to declare a mistrial. So you got to show those two things as a defendant if you're going to say, hey, look, this mistrial was inappropriate, double jeopardy is attached, you can't retry me on this stuff. So in this particular situation, they didn't object, and that's going to be used against them. But, you know, the argument that they have that they're trying to raise, and I think is a good angle for them to take, it's kind of what they have to take, is that silence does not mean I'm joining into the request. I'm just at best acquiescing in what the court has already decided to do. But that doesn't mean that I've necessarily bought into that and ratified it in a way that would be a waiver of my right to then challenge that mistrial being declared. I know Bev is going to, you know, she would take issue with that. She would, like I said, she would say, no, you had the opportunity to object. You didn't alert me to it. So had you done that, I could have considered what other opportunities there might have been, or exactly what you wanted me to do instead, but you didn't. So that's why it didn't happen that way. The problem, though, is that however you come down on that issue, there's still the manifest necessity hurdle that they have to get over, and the jury being unable to agree is classic manifest necessity for mistrials. Like, pretty much the hung jury is like the main reason why mistrials get declared. So it's a lot of murky water, because then you circle back to, well, but the jury didn't unanimously agree. But how do we know that? Well, we only know that because of things jurors told us about what happened in the deliberation rooms, and that can't be evidence. That can't be evidence. So does this seem like a form over substance thing to you guys, where, you know, the jurors say it, we should at least give them credit for what they're saying. We should give some importance to that. I mean, it could be a situation that's just form over substance. I think the problem is, though, that's just unfortunately how it's going to be here. WM Penguin. Well, at least we have a good amount of time to re-prep for all of the Commonwealth witnesses. We are all ready. Everybody is going to be ready for round 2. Yeah. Once again, such an opportunity for the defense to recalibrate the decisions that they made, the direction that they went. Because they put on such a short and tight and to the point case, they kept a lot of options open for the second time. They still have the element of surprise with a lot of stuff. The Commonwealth, what is there going to be to give us that's new? What is there new? The whole elephant in the room, the federal investigation that is lurking in the background. I don't know that anybody believes this has just suddenly come to a grinding halt. The investigation, the experiments and everything that the crash daddies did, they finished their report in February of this year. Okay? That's not a very long time at all in federal investigation land, it just seems extremely improbable to me that the feds would have invested all of this money, these resources to hire these guys to do this breakdown. This breakdown tells them this official story of what happened is not what happened. Physical evidence doesn't correspond with it. And then they say, okay, thanks, and walk away and do nothing with it. That seems very unlikely to me. So I tend to strongly suspect that we're just at a point where the federal investigation has entered a new phase. We're no longer in the surreptitious stage of investigation. We're now at the point where everybody knows that they're watching. Everybody knows. And so what do they do now? There's a whole different universe of scurrying and covering tracks and things like that people can do once they know that the eyes are on them. 6 months, a lot more time for the feds to keep working, more stuff to come out. Is any of that going to be beneficial to the Commonwealth? Seems hard to believe it would be. Seems really hard to believe it would be. But since they had put so much of their energy in the case into the pre-buttal, into calling everybody that's now, on record under oath for the second, third, fourth time for some of these people, you're just continuing to build impeachment material. You're continuing to provide testimony that they have to stand by, or it's going to be pointed in their face next time, and they're going to be reminded, when you were under oath before, you said that. So are you lying then or are you lying now? That kind of thing. They have so much more time to prep and to, keep digging, keep looking for more stuff. See what else they can find that they can potentially use. So it's a lot of time that they have to work with here. Michaeline McWilliams, what if more jurors go to the press? It was reported one went to a TV station this morning. Can it help the decision to dismiss? I did see that. It was Christina Rex, I think, is who I saw. She reported having a in-person, like face-to-face conversation with one of the jurors who had been seated. She confirmed. I sat in the courtroom. I could confirm with my own eyes this was one of the seated jurors, and confirmed that, yes, this was supposed to be an acquittal on the second-degree murder and the leaving the scene counts 1 and 3. Is it going to help the decision to dismiss? I'm doubtful. It's going to run into that hurdle of this very strict rule that you don't get to consider what jurors have to say about the deliberations. Now, I read the defense's reply, and I think the reply to that is honestly about the best one that you can have. It's all you have to work with is to argue, well, this isn't really about the content of the deliberations. It's about the result. It's about the action that they had resolved upon, not the process of how they got there. This is a good argument. I mean, it's a good distinction. That's what lawyers, often have to do. You find yourself trapped in a corner with a certain piece of law, you got to find an escape route. And so the escape route here is clearly, we got to avoid this problem of these affidavits being about the content of the jury deliberations, because that squarely places them off limits, cannot be considered by the court. A lot of areas where the law is ambiguous or can go both ways. This is really, really not one of them. It's about as close to black letter as you get. But there is a tiny little loophole, tiny little exception. I mentioned it in my Substack piece, and it ties in, I think, very closely with where the defense is going with this as well. There is an exception for correcting a verdict. And so there were cases where the verdict is read out and the jurors realize, oops, something happened here that was wrong, that didn't exactly line up with what we had done. And under those circumstances, the jurors were allowed to correct it, to make the court's, pronouncement of the outcome comport with what they had actually intended to do back in the jury room, even if that wasn't maybe exactly what they had put down on the paper or something like that. The problem with that is that it's such a limited exception. It's an extremely limited exception. It tends to only apply to things like just accidents, typos. We thought it was Form 3 and it was really Form 2, accidentally filled out the wrong form. And it's only happened in circumstances where the mistake is caught quickly, like before the jurors have even left the courthouse, an immediate correction. And part of the concern with that is because the jurors, after they are released, they're released from their oath. So they no longer have to avoid talking about the case. They no longer have to avoid going and looking at the press, seeing what everybody else was talking about, watching the videos and everything back to fill them in on all those details that we were talking about that they didn't get to participate in. And so that can taint them after the fact. That creates a bit of a problem as far as just raising the question of, well, is this really, the jury's untainted, spontaneous expression of what really happened, or is this something that maybe on reflection they decided to raise? There are some circumstances in the affidavits that kind of raise this as a little bit of an issue. The two jurors who did not personally come forward to the defense lawyers, they spoke to people who spoke to people who spoke to the defense lawyers. So we already know just from the context, the jury is no longer, in a situation where they're pristine. They're talking about it with other people. Factually, very, very, very far from the cases where the court has said yes to correct the verdict. We can go ahead and allow that. So this is a very narrow tightrope the defense has to walk to try to tie that line between, yes, the jurors are telling you about what happened in the jury room, but it's just because they're trying to tell you what they did. They're not trying to tell you this is what we said, or this is why we said it, or any of those things that everybody agrees would be off limits. They have to try to shoehorn that into the decision being a legally significant fact, and not just part of the process that got them there. I don't think they're going to clear it, guys. I've been frank about that. I know it's not what people necessarily want to hear, but this is my prediction. I'm being predictive of what I think the outcome is going to be here, not necessarily what I think it should be or what I think would be right under the situation. It's far more complicated than that. But in terms of predicting how the judges are going to read the law and apply it in this situation, no, I don't think it's going to help the motion to dismiss, because I don't think they're going to find that these juror statements are cognizable evidence. Andrew Hansen, stop Trooper Paul from being qualified as expert. Yeah, here's a potential motion in limine. We're going to severely challenge the scientific underpinning of that testimony that he gave. The testimony is out there now. We have a foundation to be able to show, a proffer that we can show This is what he said before. So we anticipate that he's going to say that again. And if he does say that again, here's why that falls short of generally accepted scientific principles. This is, again, one of those situations where it's so ironic to me. It's so ironic to me that the Commonwealth went down this road with the defense experts, right? They weren't formally called accident reconstructionists, so they don't meet the standard. Identifying the dog bite might need some kind of the Daubert analysis. The Daubert analysis is it's a standard for admission of scientific evidence in court that just basically requires a showing of basic reliability. And so it can be a way to keep speculation and, frankly, pseudoscience, overstated conclusions from being presented to the jury under the guise of being, just having that aura of scientific credibility attached to it. I'd be shocked if they didn't challenge that, honestly, because it was so obviously trash. It was based on math and things. Like, he couldn't even articulate what the basis for his opinions was. So, yeah, whole new opportunity to be able to go in and potentially take Trooper Paul off the table. Now, strategically, does it benefit them to do that? That's a whole different question. You get rid of Trooper Paul. You do potentially open the door for the Commonwealth to go get somebody better, somebody who is just maybe better prepared to riff on the fly about how they came up with these kinds of conclusions and make them sound more science-y than Trooper Paul was able to do. Whole argument to be made that, when it's this patently ridiculous, don't stop your enemy when he's making a mistake, right? If it's so obvious to everybody that this guy is a train wreck, his opinion is terrible, it's not worth the paper that it's apparently was not written on, then it just goes to show how desperate the Commonwealth is in their case. It doesn't necessarily hurt you to let them put it on, because it just makes them look bad, that this is what they expect people to believe. But that can be risky because, seems like some people maybe can believe it. So, that one is a little bit of a tough call. To me, I think everything else being equal, you try to get that opinion off the table. And so you focus on it not just because it's Trooper Paul's testimony, not just like we're trying to get rid of Trooper Paul. You really focus on the substance of it and the lack of scientific grounding for the conclusions that were reached. It's not the witness that you're trying to exclude. It's this unfounded opinion that doesn't belong in the courtroom. And if you can do that, then what? They have to come up with a new opinion. They have to come up with a new conclusion, a new basis, or we're going to go through the trial again and it's going to be based on Aruba and there isn't going to be a mechanical case for how this could have happened other than, well, it must have because there were taillight pieces that CERT found on January 29th on Fairview Road. Definitely an opportunity and something for them to have to think about. Ed 2276, will the Commonwealth be stupid enough to bring Proctor back? Boy, $1 million question there, isn't it? I could see it depending on kind of what happens in this IA proceeding. If they stick to the story of, well, these are just unacceptable words that he used, his language choice is what he's being fired for. then I don't know that it hurts him any worse than what they already took on by putting him on the first time in this trial. Because we got to see the language. We got to have it repeated to us many, many times and get us demonetized over the course of the trial. If they stick with that, the fact that he had adverse employment consequences as a result of that bad language, is that really any worse? I don't know that it is. I really don't know that it is. I think it would have to be something more fundamental to the investigation that got penalized for that calculation to change. Because if it is a situation where, say, the Massachusetts police makes a finding that, well, he looked biased, or it created an appearance that he was not objectively carrying out his investigative duties, that plays right into that Bowden defense. That is their Bowden defense, isn't it? I mean, that's it. And if they can get the Massachusetts State Police to confirm that, yeah, this guy, the lead investigator, he did not go look at other people because he was so, from the get-go, prejudiced against Karen Reed, and now you have an agency confirming that. Yeah, that's going to change your calculus, I think, from the Commonwealth standpoint, in terms of whether the risks of calling him outweigh the benefits. But if, there's just many ways in which they're kind of stuck with it. They kind of are. Because they tried to get in as much as they could through Sergeant Buchanan. Well, boy, what if we get to poke holes in Sergeant Buchanan with that Sallyport video? Now where are you? Now where are you? I did see a hint. Too, that Proctor is not the only person that's potentially being investigated out of all of this. Don't know if that's the case or not, but yeah, things could get worse. Things could get worse. But just certain things that he did, he has to testify to. He is that link in the chain of custody for so much of this stuff. He's the one that collected it. He's the one that bagged it in. It's just it's going to be tough for the Commonwealth to put on a case without the lead investigator. So, but yeah, that's going to be interesting to see how that unfolds. Allie Thorstad, any chance the DA's term is up this fall and a new one declines to go forward? That's an interesting question. I don't know when the election terms are up. Let me see if I can find out. Let's see. Try to Google something like re-election. Says he's currently in office. He's the incumbent. We know. When is the Norfolk? Let's just try to find. Okay. Election terms. District attorneys, 4 years, and this says it's in 2026. The next one is 2026. So he must have just gotten reelected in 2022. Let me see if I can confirm that. Yeah, he did. He won re-election in 2022. So he's got another 2 years on his term. And that unfortunately means, at least as far as elections go, we are probably going to be stuck with him and his office and those decisions. But I do like your thinking. This is The reality is a lot of these problems with criminal justice at the local level, they have to be solved locally. The political process is one of the only tools that we really have to kind of make sure that the people in charge of running things are doing it the way that we expect them to. So, unfortunately, not going to have time for that kind of accountability to play out with this particular case, at least not in the kind of time frame that would make a difference for Karen Read. Could it hurt him in his re-election campaign in 2026? Well, we can definitely see about that. John Beatty Bott, her verbal instructions precluded jury partially filling forms. That must be error. Doing that and then not asking shows signs of scorching. So I went back and looked through exactly what instructions Judge Bev had given about how to fill out the verdict slips and then what the form instruction is for the same thing. So I've got those clips in my Substack piece as well. But basically, she did deviate pretty substantially from the form verdict, the form instruction. And the form instruction does make it pretty clear, although it's, they don't come out and say just directly, if you've only reached a verdict on one, go ahead and fill out that form and then, move on to the others. They don't specifically say that, but they do say for any charge on which you can reach a verdict, then you should fill out the verdict slip and the jury foreman should sign it and initial it and so forth. So it's broad. It's any charge. It's not all charges. It's not once you've decided everything, then go ahead and go in and fill these out. So then when I went and looked through what Judge Bev had said in her own instructions, she did not use the form language. She kind of reorganized how she did it. It looked like she just basically has her own script that she's probably developed over time. And so in some places, she used that same language, that any verdict, any charge that would, seem to then avoid those kinds of problems with confusion about what the options are. But then there were other points where, it suggested when you've reached a unanimous decision on the charges, then move forward. So potentially ambiguous. Is it going to help them in this particular case? My suspicion is probably not, just because what she actually, there's a couple reasons. Once again, definitely when it comes to jury instructions, the burden is on the defense to object. They have to object. If they don't object, then you typically waive your objection. You typically waive any error that comes out of that decision. And so jury instructions are a really classic case where you have to, it's very common, and they did it in this case procedurally, to have this jury instructions conference. And so typically what happens is the judge so the parties have submitted with whatever they want to be given. If there's additional things that the judge needs to give, like they do in this case, there's kind of a standard script that they're supposed to use. The judge incorporates all that, puts them in the form, and then provides everything to the parties to be able to look through so that they can then go on record in this instructions conference and go through, this is what I'm going to say. This is instruction number 1, instruction number 2. Do you have any objections or exceptions to the jury instructions? And that is their opportunity to say, yes, I object to this instruction being given. I accept from the decision not to give an instruction that I've asked for. And that preserves your objection for appeal, because it's alerting the judge to the fact that you take issue with it. Because if they don't know you don't take issue with it, they don't have the opportunity to fix it. So in this particular case, they didn't object to her jury instructions. And especially with that second one, the supplemental that she came back and gave after there was the kerfluffle about verdict form 2 not having the not guilty option. for all of the lesser included, or I should say each of the lesser included offenses. It presented it as an all or nothing decision that they had to make. And that's simply not what the law is. They can acquit on greaters and then fail to reach a decision on a lesser. So her response to that whole issue was to add in the form language from the verdict slip that the verdict slip that had gone back to the jury did not have. That's, clarified what exactly they were, that the, not guilty verdict would apply to all the charges, and, not potentially just some of them, not just the greater charge. And then she gave the supplemental instruction on basically how they're supposed to handle this going through the verdict forms. The defense didn't object to any of that. And not only did they not object it, they said, yes, we're satisfied. This resolves our concern that we had raised about the verdict slip. So that not only waives the error, that potentially puts it now in the ballpark of invited error, where you went along with it. And once you go along with it, you don't get to change course after the fact and say, never mind. If you had, voiced it at the time, the judge might have taken a different route, but because you were on board with it, it kind of induced the judge to go the direction that they did. So that is going to be a likely insurmountable hurdle for them to overcome as far as challenging that supplemental instruction. So, yeah, guys, this I guess today is maybe form over substance day. This is our theme for today's discussion of the law. In a perfect world, they would all align. Right? Everything would align. The form, the process, the requirements, they exist the way that they do, so that you get the right outcome, right? So that the substance of the result that you get is the fair one because the process that produced it was fair. It's just that fair process gets so complicated, and it's taking into account so many things beyond just, did the jury get the right verdict? They're also looking down the road at, did everyone get a fair shake? Did the judge have a fair opportunity to rule? Was everybody on fair notice of what was at stake here? It's because so many of these other things that go to really the finality of the decision, more than the quality of it. Those things can, get in the way of what looks like the fair outcome. So I've mentioned before, it was Justice Scalia who made this comment. That's just horrifying. It's horrifying. It's horrifying to me as a lawyer, like that you say the quiet part out loud, but it's legally, it's hard to argue with him. Justice Scalia was talking about the difference between procedural due process and substantive due process. And so procedural due process is the idea of the rules, the procedure, the fairness, the opportunity to have a fair shake, be treated fair by all the parties, those types of things. So like Brady violations, for example, are a violation of the procedural due process, because if you're hiding stuff, this is not a fair trial. You're like sticking cards in your sleeve, basically. And that can't be expected to produce an outcome that's fair. It's not the outcome itself that's the focus, though. It's the process. Because if the trial is supposed to be a truth-finding process, discovery is supposed to be open, then that exculpatory evidence needs to be considered for the jury to have a chance at getting the right decision. Substantive due process is much more getting at the core of what is fundamentally right and wrong. And the statement that Justice Scalia had made was that it would not violate due process for a factually innocent person to be put to death by the state so long as they had received all of the process that the law allows them. It's a horrifying thought. And part of the reason why it's horrifying is because it probably has happened. It probably has happened that factually innocent people have been put to death by the state because, well, they had a lawyer. The lawyer was awake throughout the trial. There was a trial. There was a jury. The jury was unanimous. He had a right to appeal, and the appeal affirmed the verdict. And there's post-conviction processes that he has the opportunity, if he has the resources, to be able to pursue. If there's evidence that didn't get presented to the court or other grounds to think that this outcome is a fundamental defect, a miscarriage of justice. So either those didn't go through, or, those procedurally maybe were defaulted. You got strict time limits to file a habeas corpus petition. Maybe you filed it a year and a day later. Yeah, well, you got your procedural due process. Doesn't matter how good your case was. Procedurally, you slipped, and now you're out of court. It probably happens a lot. And so I guess maybe the balance really does fall a little bit more on the side of that, on the form over the substance. We make a lot of omelets. We crack a lot of eggs in the criminal justice system. Ms. Holmes 66, Andrea, how can Bev just ignore the jurors who have come forward to defense attorneys and not address their outcry of acquittal? She is going to say the law precludes me from being able to consider these statements as evidence. The law is clear that jurors' testimony, jurors' statements about the content of what they did in the deliberation rooms cannot be presented as evidence in court. So I am not at liberty to second guess the judgment, the wisdom of the law. It is merely my duty to apply it and to follow it. And given that, I may not consider these affidavits, no matter how compelling they may be. That's what I expect from her, something along those lines. That's if she is, and I expect she will. There's going to be some tension, I think, with Judge Bev, where on the one hand, she really wants to lay into the defense for raising this. She's really going to want to, because this is going to build on that snark that she gave to David Yannetti that we saw during the trial when she's like, argue to me, Mr. Yannetti. I'm the one you have to convince. She's implying that he was arguing to the cameras. This was in the course of the motion where Mr. Lally had, suggested that the defense took the dog bite theory off the table. He was quite offended at that. Judge Bev was offended that he was offended. She is likely to see this motion as far more of a PR play than a legal one, because it's such a long shot, and because, they would have to convince her that this evidence is actually admissible and something that you can and should consider. And there just isn't really precedent on their side to support that. So on the one hand, she's going to want to lay into the defense about this. But on the other hand, she's going to want to show respect for the jurors and their experience and their thought processes. We saw throughout the trial how whenever Judge Bev was addressing the jury, She could not have been sweeter. She just loved being able to tell them, jurors, you're all done for the day, and we're so grateful for your service. And sometimes things come up during the course of the trial, and we really apologize for your inconvenience. It's very typical of judges to be deferential to their jurors, in part because these jurors are among the people that will vote for that judge or against that judge when that judge is up for re-election, although that's not particularly the case in Massachusetts, where they have the appointments. But it's just because, they do want to encourage people to want to serve as jurors. They want people to do their civic duty. And so you don't want to discourage people or malign them or invalidate their experience, discredit their perspective on what happened and why it seems to them like what happened in this case doesn't really seem to line up with what I thought we were doing. She's going to, I think, be torn between sort of needing to acknowledge that in order to validate the jurors, to continue to support them and encourage them to continue to show up for jury service. While on the other hand, really wanting to use it as a cudgel against the defense. So we'll see how she comes down on that. But if she were being graceful, I think that's something basically like that's a way that she could handle it. My hands are tied, however compelling this might be. The law provides that this is not cognizable evidence, and I am not allowed to consider it. Ed2276, someone in chat mentioned Bev told the jurors not to fill out any jury verdict forms until they came to agreement on all 3 counts. Could that be an improper jury instruction appeal? So yeah, we talked about this. It's not that clear to me that is specifically what she said. I think you can read what she said to say that. But it's not the only way that you can read what she said. So I think it comes down to a question of ambiguity. When it's ambiguity, the burden is going to be on the defense to object and to request that it be clarified. So the fact that they did not do that it's likely to be a pretty big problem. Now, if I'm wrong and the instruction that she gave was definitively legally incorrect, like she specifically told them they have to do something that's not legally required, then it's possible the defense could shoehorn that into what's essentially a manifest injustice exception to that rule that you have to preserve error at trial by objecting. But that's always a tough call. It's very, very challenging. It's a limited exception, and they're always going to be inclined to think, look, if this was such an obvious problem, you would have raised it. You're clearly competent attorneys. You were paying attention. You litigated stuff throughout the course of the case. It's not, a situation where the defense lawyer was, drunk and sleeping through trial and, probably didn't notice anyway, in which case we might be a little bit more generous in our perspective on why certain things were and were not done. I don't think they're going to get past that not objecting. It's just going to be it's going to be too difficult for them, I think, to argue that this was a foreseeable problem. I mean, and in fairness, I didn't foresee it. I don't think anybody foresaw it until it happened. So, Millie Martinez, what cases do you plan to cover in the coming months, Andrea? Well, thank you so much for asking. I have been giving this some thought. Because I don't want to just, completely vanish for months until there's Richard Allen or something like that to jump up. So I have been looking at some other cases to pay attention to. So over the next couple weeks, I'm watching the Ashley Benefield case. So first off, I want to say I am not planning to live stream this one like on an everyday basis, because there's just a few reasons. I have some scheduling conflicts over the course of the next couple weeks when the trial is supposed to happen. So I wouldn't be able to do it every day, and it's just that could be awkward. But what I do plan to do is I plan to watch it and kind of keep an eye on it. And then as there are things that happen over the course of the trial, over a day or something like that, then I, would like to go ahead and do a live stream that's a little bit maybe more of a recap than just a straight live watch. So that case, if you guys have not been paying attention to it, it's one that is not real legally complicated, but it's factually going to be really the dispositive issue. So Ashley Benefield, she's charged with murdering her husband. This was a very rapid romance. They got married something like 2 weeks after they met. There's a large age discrepancy between them, and the relationship really appears to have been very volatile, probably from the beginning. I mean, you can tell if you start on a high of getting married after 2 weeks. Yes, things are volatile from day one. So they had been going through a divorce. There were accusations of abuse by Ashley against her ex-husband in the course of a child custody dispute. She was seeking full custody of their child, preventing the father from having access to the child. He was contesting that. And ultimately, there is some dispute in the home. Not real clear factually what happened, but husband is killed with a gunshot, several gunshot wounds. Ashley claims that he had charged her, he was assaulting her, that she shot in self-defense. The prosecution, this case is in Florida, the state is disputing that. They're saying, no, the entry wounds don't line up with him being a threat. She doesn't have any injury. There's no evidence that there was an ongoing threat. So it's one of these situations that, from my perspective, it's not entirely clear who's at fault. Back in the day, right? You just assumed. Everyone just assumed. The woman must have been the victim. Everybody assumed that. And then Depp v. Heard happened. And it's not really a safe assumption anymore. All of those excesses of Me Too came out, and people started to see, wow, women do wield false accusations as a weapon. We've been told all this time women never lie about things like that. And maybe it seemed intuitively wrong to us, but you weren't allowed to say it. Yeah, we're kind of allowed to say it now. And so that's really going to be the question in this case, is who was the aggressor? It's not unheard of for people to wield abuse accusations in a family court situation, to wield the children, try to alienate the parent, use all of this as a weapon against a victim who's trying to leave. That's a conceivable interpretation of the evidence from what I know about it so far. But obviously, certainly not rare at all for, somebody to be in a relationship, be under a massive amount of control and stress and abuse, and ultimately crack. That certainly happens as well. So I'm interested in this one just because it's one of those ones where it is important to get it. It's important to get it right. You know, re-victimizing people who have been victimized is, you know, one of the worst uses of our criminal justice system. And so you always hope that that is not the case. But until we get to trial, we just don't know. Till we get the evidence, we aren't going to know. So if she claims he's abusive, we're going to need to see. We're going to need to see some history. We're going to need to see the dynamic. We're going to need to see how that plays out. I'm expecting there's likely to be an expert. There usually is in cases like this where there's a battered women's type of defense being raised, because that's their whole objective is to go through and look at the relationship from the outside, all of the information that they can find that's objective about it, the communications between the people, any types of previous reports that were done, their relationships, you know, things that they said to other people, things that other people witnessed. Just what is the flavor then that you get out of this relationship from that type of evidence? And typically what they're looking for is one person is trying to control the other person. And it can start with subtle things, small manipulations. It can grow into, you know, serious psychological abuse and violence. But that's ultimately what they're looking for is if we can see this relationship from a 10,000 foot as much as we can, which one of these is trying to control the other? Because that's going to give you the best insight into who is probably the abuser in the situation and who is the one that's reacting to the abuse. So Ashley Benefield does have a big support network behind her, a domestic violence survivor support network, which, you know, we have seen before. It's not necessarily, you know, a good predictor of whether this person is in fact a victim or not. So I'm interested in that case. I don't know if that's something that you guys might be interested in as well, but if you are, like I said, I'm probably just going to watch it, look for the interesting stuff, and then give you some recaps as that comes up. Otherwise, yeah, I'm probably obviously waiting for the motion to change venue in the Koberger case. In fact, when is that one? Let me look that up real quick, because I know it's coming up in October, but it's not exactly right around the road. I have it written down. August 29th. Yeah, so that's quite a ways down the road still. But I will definitely be on that. And then if anything else on that case comes up in the meantime, I will be watching that. So State versus Richard Allen, the jury trial is scheduled to start on October 14th. It's scheduled to run through November the 15th. This is one where I am planning to be there in Indiana because they are not going to allow cameras in the courtroom. So this is a situation where getting good factual reporting about what's happening is you know, potentially kind of important, just given what's at stake, the questions that have been raised about this prosecution, the investigation, whether they have the right guy, how they treated this guy, all of this stuff. It's just a very messy situation, and not being able to see for ourselves how it's unfolding is going to make it difficult for people to form a judgment about whether it's fair or not. So that one is a very high priority for me. Pretty much, you know, no matter what, I'm planning on that. But that is also a little bit down the road. So, you know, if there are things coming up that you want me to look at, I will consider it. I will say this off the bat. I don't really want to watch Sarah Boone. Please don't make me watch Sarah Boone. I don't really want to watch Sarah Boone, just because I know how it's, you know, I know how it's going to go. I know how it's going to go. I've said before, this defendant is just, she's a female Darrell Brooks. She's a female Darrell Brooks. We're going to see that same trial, same tactics, the same obstructionism, the same kind of, delusions of grandiosity, all of that type of thing. The interesting thing in that is not going to be her as much as it's going to be the judge's reaction to it. How does the judge manage the courtroom? I will say personally, I didn't love how the judge in the Darrell Brooks case handled that courtroom. She just was too reactive to him. It's kind of old wisdom that with narcissistic types of people, the gray rock tends to be the effective way to go. You can't give them the reaction, because the reaction is the fuel, that is the supply. So I thought that judge was a little bit too willing to react, to give credence to what he was doing and what he was saying. There was no way you're ever going to convince that person. He's never going to see things your way. So you got to kind of get past thinking that there might be some sort of benefit from entertaining that kind of stuff. You deal with the legal issue, address it, move on. He's going to do what he's going to do. She's going to be the same way. So to the extent I have even a nominal interest in that case, that's really what it is. I would be somewhat interested in seeing how is the judge going to handle this, because frankly, the judge to date seems to have been remarkably lenient to my perspective. The judge did ultimately find she had forfeited her right to counsel, which is a pretty tough move. But frankly, could have been justified 3-4 lawyers ago. I think it was lawyer 7 when they finally made the lawyer 7 moves to withdraw, and the judge finally decides you've had enough opportunities. You're the problem here. You're the one who can't get along with your lawyer. So, they're going to tiptoe in all likelihood, because they're worried about appeal, and they're worried about doing something that could impair her rights or whatever. But these trials they end up being difficult to manage. They end up being kind of circuses, and I don't enjoy that. I find it stressful. I find it very stressful enough having to have represented, people with these kinds of personalities and kinds of characteristics. Don't necessarily need to go bathe in that some more for fun, but I don't know. I guess I'm not like 100% on it, but I really don't want to, so don't make me. But yeah, like I said, if there's other cases you're interested in, definitely bring them up, and I'll take a look. It's kind of seemed to me like we're maybe in a little bit of a lull. As far as interesting things going on. Some people I know have mentioned, and I would definitely be receptive to this. I started to look at the civil case that's going on about the Sandra Birchmore case, the case that her estate has filed against, Matt Farwell and just the other people involved, the Stoughton Police Department, all those guys. And so it is definitely in the morass of the civil litigation, but I am definitely interested in going back and taking a little bit of a closer look at what has transpired in that so far, because it has gone through some pretty significant procedural hurdles that it's already cleared. So just kind of get people up to speed on what's alleged, what do we know, what's the status of it, what's likely to happen at this particular point in time. So yeah, other than that, that's really all I've got kind of on the horizon in the short term. I'll keep an eye out for anything that you guys may have. Ms. Holmes 66, what about the fact that Auntie Bev should have recused herself, as she is connected, albeit indirectly, to the McAlberts? How is this legal? So this is an issue that it was an appeal issue before this trial. It will remain an appeal issue if she gets convicted on a retrial. They're always going to have the opportunity to challenge her bias and the argument that she should have stepped down because the connections, that she has should undermine like a reasonable person, an observer's confidence in her being unattached to any side. I don't know that they have the best record so far of what exactly her connections are. So far, what I know about them, they seem a little bit tenuous. It's things like her brother represented, who is it, Paul O'Keefe? Or one of the Alberts? There was a connection with somebody that her brother represented. That's probably not going to be enough to show a specific connection with her. Then the only other thing that I remember was the tweet. One of the McAlberts tweeted at Turtle Boy, I think, about Judge anti-Bev, it's where the anti-Bev came from. We're going to bury you under her, whose seaside cabin, beachfront cabin do you think we're going to bury your corpse under, or whatever. That doesn't look good, but it's again, it's just not something I can put a lot of credence to, because I know what it's like for people to be, they have no connection with you at all, but they'll pretend that they do. They just know your name. Like, you're a lawyer. I can't tell you how many times, somebody will throw my name out. Like, somebody in prison will throw my name out because I represented them on an appeal, 10 years ago. And they'll be mad at they lost a privilege or something like that. And they'll throw my name out at Department of Corrections. Oh, Andrea Burkhart's going to come after you about this. Well, no, I'm probably not. And we've never talked about that. And I'm not representing you on that. It's not the nature of our relationship. So I can't really hold what other people say like that against her. There needs to be a better record, in my perspective. If she is connected, if she went to school with these people, if she's worked with these people, what the nature of that is. There has to be a better record made, because for better or worse, she did a pretty good job, I thought, in the first trial of being pretty even-handed with her rulings. Not all the time, not every single one, and I definitely did not like just the attitude, the different attitude, total demeanor shift that she had between one side and the other. You're yelling at Mr. Yannetti, accusing him implicitly of arguing for the cameras and instead of to you. And on the other hand, you are sucking up to the Commonwealth for raising an argument that no prosecutor should ever be arguing that a defendant trying to hire a lawyer, an accused person under suspicion trying to hire a lawyer when the cops are coming to talk to them is evidence of guilt. Ugh, I didn't like that. But it's not going to establish the kind of attachment, the kind of bias that would be necessary for that decision to really stick. Otherwise, it's once again going to kind of fall back in the framework of her discretion. Do her decisions fall within the range of permissible outcomes a judge could reach under the circumstances? Yeah, I can't say I've really seen anything that's so out in left field that your jaw drops. She does it. She doesn't always rule the way I would like her to, but I haven't seen anything that it's like she's completely disregarding the law. She's, not giving the defense any kind of a chance. You know, even when she cut off Mr. Yannetti, she ruled for him, you know. So establishing bias with that kind of record is challenging because she can always point back at the transcript and say, look at here, look at all these times I ruled for the defense. Clearly I wasn't biased. And that's then what they have to overcome. They can do that if they have a good record of those kinds of internal connections. But so far, I'm just not sure that I've seen anything that that really meets that standard. Alyssa Ramirez, would be cool if you brought on a UK lawyer to review the Lucy Letby case for a video. I looked at the Lucy Letby case. I would definitely need a UK lawyer to help me out on this one because I learned during Det v. Heard that trying to sort out for myself what is going on with UK law, it's a nightmare. It is. For a system that our own has its roots in, it sometimes seems so foreign as to be really incomprehensible to me. So I don't always have a good clear perspective on really what the options are, what's available to them, like what can you even do given a certain set of evidence or facts and a procedural posture. The Lucy Letby case, she had been convicted of multiple counts of murder. She was a nurse, and it was alleged that she was killing babies under her care in the hospital. And so subsequently, she's been convicted and sentenced. And subsequently, there has been some new evidence that has apparently come to light that calls into question the theory of how she allegedly committed these murders. And so, it's not real clear to me whether under their procedure, you know, the rules that they follow in the UK, whether this is going to be grounds to potentially reopen her convictions, grounds to seek a new appeal. They have a very different appeal process than we have in the United States, where you get convicted, you have so many days to file your appeal. Your appeal is limited to legal issues. You have so many days where you can file a habeas type of post-conviction petition or process. That's your avenue to potentially present new evidence and argue other grave miscarriages of justice, that type of thing. It seems a little bit more nebulous in the UK. Like, honestly, from my outsider's view, sometimes it looks like it's just, well, do they really want to? Do they want to look at it again, or do they not? So I don't know. But it is interesting. I did not watch that case or follow that case really when it was happening, other than just kind of being aware, you know, that it was. So I really don't know how strong the evidence was in the first place. But the new evidence that they brought forward, it was a little bit alarming. It basically had to do with the so if I remember correctly, what had happened was she was accused of injecting insulin into the babies. And so that would cause a blood sugar drop, and the babies would, go into a coma and die. And apparently there are it seemed like maybe one of the reasons why she did this is because there are other natural infant deaths that can look a lot like this. So I think it was like she was trying to disguise it as a natural infant death. But the prosecution is arguing, no, this was something that she did with insulin. So the challenge then is that, the founding doctor who talks about this particular condition is basically saying that it's not consistent. The state's theory is not consistent with these types of infant conditions. It wouldn't work like this. So potentially undermines it. It reminds me of cases. We have quite a few cases in the US still that deal with what they call shaken baby syndrome. A lot of these cases they happened over the last probably 10, 20 years or something like that. And it's only recently been, I want to say within the last maybe 5 to 10 years or so that this whole theory of shaken baby syndrome has really come into question. That pediatricians are kind of starting to recognize, these clusters of symptoms that we used to assume could only arise if a baby has been violently shaken, resulting in its death. It turns out they can be caused by other things. So there have been cases of those convictions being overturned. There have been cases of those convictions, continuing to stand, notwithstanding kind of changes in the scientific understanding of it. Just to bring us back to that form versus substance problem, right? Doesn't matter if you didn't actually murder your baby, as long as you got the procedural opportunity to try to prove that you didn't. So a little bit of shades of that with Lucy Letby, and I'm really not sure how all of that is going to unfold. But yeah, I'll consider taking a look at that. That does sound potentially a little bit interesting. My cat's name is Karen. Dr. Ben Brown is going to trial in August for manslaughter charges of his wife, Hillary Brown, who died during a procedure he was performing in his office December 2023. You can cover his trial. I'm going to write that down. Dr. Ben Brown. I will take a look at that. Yeah, that sounds like an interesting one. Was it a procedure he's performing on her in his office? That's a little bit of a red flag right out of the gate right there. Not that it's like as I understand it, it's not a black and white rule that a doctor can't treat somebody that they're related to or a close friend or something like that. It's not like a hard bar that they can't. But a real strong preference that if at all possible, you really shouldn't. It's just generally better for somebody who has a little bit more distance to be in charge of that treatment so that they can be a little bit more objective. So yeah, that's a little bit potentially alarming. Thank you for the suggestion there. I will definitely take a look at that one. Alyssa Ramirez, maybe a series of trial review videos for Zachariah Anderson. I am still so behind on Zachariah Anderson because I didn't watch the trial when it happened. And now that they are on appeal, my thought process has been, look, appeals are kind of my specialty, right? It's what I did exclusively for the last, 5-6 years I was in legal practice. So that's really my wheelhouse, and it's where I could potentially, I think, have the most insight about it. But it appears that the appeal process is moving quite slowly. And, it often does. That's not unusual. Appeals are kind of always at a snail's pace. But it's just until certain things happen, like the briefs get filed, the record is available, stuff like that, it can be a little bit difficult to take a look at that. But I do want you to know that has been on my radar. I've got it noted to kind of check in periodically on the appeal status and see where it's at, because I know this is a case that a lot of people did not think that this outcome was called for. I understand there were like shenanigans after the fact and concerns about back to overstating conclusions about the evidence, that it has this aura of being solid science. If it's DNA, it must be solid science. Well, no, not when you distort the significance of what the presence of that DNA actually means and the kinds of conclusions that can be drawn from it. So these are, potential issues on appeal, and I'm interested to see how that plays out and what types of arguments they have to work with. So hopefully that will get filed, one of these days, and then I'll be able to take a look and break that down for you guys as well. So yeah, that's some good stuff on the horizon, I think. But yeah, well, not so exciting in Karen Reed today after all. I guess that's just what happens sometimes. But we got our dates. And we know that what that means. We know that this is a rare situation, I think, where time is on the defense's side. Often that is not the case. Often the sooner you can get to trial, the better it will be for you, because just the more stuff unfolds, the greater potential that it will not go in your direction. Karen Reed's case, that really doesn't seem to be the situation, just given the configuration of who is involved and what is being looked at, what the theories are. Hard to think that in another 6 months, the prosecution is going to be able to come up with better evidence that Karen hit him with the car. Just seems real unlikely. So, August 9th, I will be back for that for sure. We will watch the oral argument on that motion hearing. Guys, if something comes up in the meantime, I try not to be a big grifter, but, go ahead and have the notifications on. I confess to not always being the best at planning way ahead. I'm trying to approach this content creation thing as a little bit more of an art than a science. I'm not looking for a job. I don't want a job. I'm giving commentary because I enjoy it and it seems to be valuable to people. But there's a piece of it that is important to me to keep it working the way that it should. It's got to be fun, and to be fun, it's got to be inspiring. I got to be inspired to do it. It can't just be like a drudgery of, I'm gonna sit down and watch another boring trial or whatever. You wouldn't get very good. You wouldn't get very good feedback from me if that's what I'm doing. So I don't always know when inspiration is going to hit. But when it does, I will let you know. Just have the notifications on and it will come up. I'll go live or I'll do a video or something like that. Again, do feel free to follow the Substack. I wanted to also mention I still got some closure to get to with Alec Baldwin. Oh boy. That trial went from one of the most boring things I'd been watching in years to what on earth just happened in the course of a single day. I'm still kind of processing everything that happened and what on earth and how do I reconcile this with the law as I understand it? And is this Alec Baldwin? Did he get Hollywood treatment in here, or was this, really, really called for? Just a lot still swirling around with me that I'm kind of working through in my mind. So I'm working on a Substack piece on that too. But we gave the panel watch, the live watch with the panel, a little bit of an experiment. And I got a lot of feedback on it, guys, and I appreciate everybody's feedback and everybody's comments on it. I don't think I'm probably going to live watch again with a panel. Just didn't really work with the vibe, I don't think. I like having that ASMR influence, right? It's stressful enough watching a trial. It's better for it to be a little bit calming and reassuring as we go through the roaring rapids. And you don't really get that vibe so much with the panel. I think where the panel is really the most valuable is more with the recap, with the analysis, the after the fact, the putting your heads together and what did you think of this and what impression did you get of that and where do you think this is going to go? And if you were the lawyer, how would you have handled this situation? That type of thing, not so much just the ongoing reaction as the trial is going forward. But it was an experiment that I thought it was important to do, and I'm glad I did it. I did enjoy it for what it was, and I enjoyed the panel. I enjoy everybody on the panel. I think everybody has good insights and good perspectives to bear on what they're saying. So I did enjoy it. But I probably won't be doing that for a live watch again in the near future. So go ahead and protest in the comments if if you want me to change my mind about that. So in the meantime, guys, I'm going to go ahead and wrap it up. I will plan on being back, if not sooner. I'll be back on August 9th for this this hearing on the motion to dismiss. See what we get out of that. I will try to put out some stuff in the meantime. Like I said, already been working on Birchmore. Already been working a little bit on Alec Baldwin. So I don't plan to be a total vacuum or anything, but don't know that I am going to dive real deep into a new trial in the short term. Keep an eye open, though, for anything on Benefield, because that will probably be something that, like if I'm watching the trial over the course of the day and there's something really cool that happens, I'll just go ahead and go live to bring that up. So it'll probably be a short notice type of situation. So thank you guys all for coming back, getting our dose of Karen Reed. We thought it was gonna be all over. But nope, there's still more. So I just want to appreciate everybody who's stuck with me throughout this case, throughout the other cases that we've looked at. Really appreciate your comments, your feedback, your chats, your support. It means a lot to me. So thank you all very much for being here. And I'll look forward to seeing what we get on the motion to dismiss. So if I don't see you before then, guys, I will see you on August the 9th for that hearing. Take care.